Good afternoon, everyone, and welcome back to this week's episode of the Digital Law Podcast, brought to you by Digital Law and produced by Anson Evaluate. As a bit of background, we at Digital Law are a niche law firm specialising on working solely in the technology and cybersecurity law sector. In each episode, we look at recent stories in the news related to digital technology from around the world, with a specific emphasis on data protection and cybersecurity. For more information on the stories that we are covering this week, check the link in our show notes. By way of an introduction, I'm Amelia Davies, an apprentice solicitor at Digital Law UK, and I'm joined by my colleague, Peter Wright. Peter, if you want to introduce yourself there.
Okay. Thank you, Amelia. Hello, everyone. My name is Peter. I'm a solicitor. I'm the managing director at Digital Law, and we've got quite a large number of stories. It's funny how over the course of a few weeks, lots of things seem to have happened. So there's actually more stuff that we couldn't tell you really on this episode than what we can, just because we had to prune it all down to make it an even mildly manageable number of stories. So I'll pass back to Amelia to start us off.
Thanks, Peter. So I will dive into the stories that we're going to be covering today. Firstly, we've got the car hacking, and this is looking at the software used by the police. Then we've got a class action story. Then we've got Elon Musk's fundraiser for Trump, law firms paying ransomware attackers, Google's illegal monopoly, Microsoft being down again, which we may or may not cover. We'll see whether we've got time for that one. The Essex School reprimand, Huel and Zoe advertisement ban, and the digital will service. So before we dive into all of those stories today, here is some background information on our podcast producer, Anson Evaluate. Anson Evaluate are a consultancy company offering a variety of services, including data protection training, outsourced data protection officer services, and specialised in advising clients over multiple jurisdictions. With that in mind, let's dive into our first story. So this is the car hacking software that is used by police. So a privacy campaign group have accused the police of unacceptable secrecy after almost 2/3 of the UK's police forces have refused to confirm whether they utilise specialised car hacking software, which can download data ranging from sat-nav destination history to text messages and even bank details from cars on board computer systems. This comes following a Freedom of Information request by the I newspaper, where 30 of the 45 police forces questioned refused to disclose whether they employ advanced digital forensic technology to collect evidence on suspected criminals. It's quite an interesting story, this one, in the fact that, they are going to be collecting this data, and it doesn't seem like they're going to be very transparent about it.
No, and it echoes a few things that we already know in terms of how the police carry out their investigations. So several years ago, I attended a presentation that Privacy International gave, where they showed what a typical police force will do when they seize electronic devices, so phones, tablets, laptops, and they basically showed a device that they would use. They would attach the phone to one of these devices, and it would strip out huge quantities of data. So during the lifetime of that mobile device, which mobile phone masts did it connect to, which Wi-Fi networks has it ever come into contact with, what text messages have either been sent or received, even things that the user thinks they have deleted. Very often there is a residual data file, and this thing went so deeply within the device, it would strip all of that out, as well as every single web page that's ever been looked at. Imagine the length of the list on the average mobile device that would include, as well as all the WhatsApps that can be accessed, and any other messaging device, messaging system that it might be able to get access to. The data was incredibly rich. So the logical extension of that is that anyone who has bought a new vehicle within the last 5 years will know that the average car now contains just as much data in terms of, it's got a screen where it will tell you where you are, what you're doing, what the local speed limit is. So the police have said, yes, they are freely getting hold of information that includes where that vehicle has been. Now, this could be incredibly useful. It could exonerate you. It could say, I was nowhere near where the police say I was when such and such a thing was committed. But in the same way, it could also be used to incriminate you. So it's just the fact that now we have to view vehicles as a similar trove of information. I mean, it's incredibly useful for the police. A huge amount of their investigating now involves what's on mobile devices, what they find from what's on people's social media profiles, as well as texts that are exchanged and received, to build quite a sophisticated picture in terms of who people are, where they've been, what they've done. And this is merely an extension of that digital investigatory work that is carried out. What I think is interesting here is how few of the forces, a majority of them, didn't want to really go into any detail about how they're using these systems. Why would they do that? Well, some of this stuff is expensive, so some of the forces admitted spending tens of thousands of pounds on training officers on how to use this equipment, as well as probably having to get hold of licenses to use some of this technology, or indeed probably paying for physical devices. It could be that there's something that you actually have to plug into a socket on the vehicle in order to access some of the information. So all this does is it reveals to us, as I say, the depth of the digital surveillance work that the police can now carry out when they are carrying out investigations. One interesting thing it does say in this as well is one of the forces was saying, well, we only use this on very serious cases. So if there's a murder, then we might go down this route. We aren't necessarily doing this for the lower grade offences. But you have to think that if it's fairly easy to do this, to be able to get hold of this sort of information, and particularly if they're paying for the licensing and they've got the kit already, you can imagine that particularly if it's an investigation and they are short of leads, being able to then think, well, okay, we've seized this vehicle, let's see what information we can download of it, that could be incredibly useful.
Yeah, and like you say, Peter, this is going to be happening more and more where we have got new technology and newer cars which enable to get more of a trove of information that's readily available. I mean, if you're trying to get it from a car that's 20 years old, probably not going to be all that useful. But you've got even your car's a couple of years old, but it's very jazzy in terms of the systems and bells and whistles that you can make it do.
My vehicle is more of an industrial vehicle as well, as it were. So, and even that has stuff to the gunnels with this. So if you get more of a performance vehicle, so a friend of mine drives a quite sporty Mercedes, and the number of settings and ranges and things in terms of what you can and can't switch on is truly mystifying. Not to mention the fact that sometimes those systems will switch themselves off or on at inopportune times, like its traction control, when he's not expecting it. So only occasionally almost causes a serious accident, but that's a story for another day.
Thanks, Peter. So moving on to our next story, we are looking at the class action. So a class action lawsuit is being brought against the background check company National Public Data. And this alleges that the personal information of 2.9 billion individuals has made its way onto the dark web via a data breach. So National Public Data uses a process called scraping to collect and store personally identifiable data from non-public sources to carry out background checks on billions of people. And just to confirm, folks, this is a class action that is in the US. Therefore, there are significantly different procedures involved here. But nonetheless, talking about almost 3 billion individuals, which is by no means a small amount of people.
Indeed. I think this is a good story in that it illustrates the very different approach to personal data that they take in the US and indeed around the world. So a number of times I've had to advise organizations that are saying, look, we're collecting data through scraping, which is incredibly common. But if, for example, you start storing or processing the data of EU citizens and you're not doing it under one of the 6 bases of processing under GDPR, you will have a problem. However, if you're outside and you're not actually processing the data of EU citizens, have at it. And that seems to be the approach, certainly, that's taken in a number of US states. But it turns out that you can't really do that on an entirely unencumbered basis. So in this instance, I mean, you've not got any federal data protection law in the US. You do have some individual states with some comparatively more stringent data protection laws than others. But generally, you don't get the sort of all-powerful data protection regulators that you get in Europe in the States. What you do have is that where you have laws and a legal basis that might argue that, well, actually, we do have a legal framework here that prohibits some of these steps, then the idea is you can then turn around and say, well, actually, we're going to get together a cohort and have a class action lawsuit. And the difference there from, say, a piece of group litigation in the UK, group litigation is where you have to get everyone together and you have a register and then they collectively bring the litigation. A class action can happen for a whole cohort of people And you might not know that you are part of that class until you then end up sort of receiving a notification saying, oh, due to a class action, you're now entitled to $500. So my wife is a US citizen, and that occasionally happens, and it's quite amusing. But it's a very different approach to what we do in Europe. But in this instance, that's what we're looking at here, a massive class action lawsuit on behalf of 2.9 billion people. Whether they will all get a amount, or whether they, it's going to be, congratulations, you're part of the successful class action, and we split the amount between 2.9 billion, and it's worth 20 cents each. Is more likely the outcome that might come of that if you're successful. But it just illustrates the fact that data scraping is not necessarily something we certainly wouldn't recommend it to any businesses that are going to process data of EU citizens. But this is the sort of action that could then mean that in the States you start to think a little bit more carefully before engaging in these sorts of practices as well.
And it isn't just kind of the breach they're looking at here. So the plaintiff, Hoffman, accused these guys of negligence, breaches of fiduciary duty and third-party beneficiary contracts, unjust enrichment, and is therefore fighting for financial compensation and for the defendant to segment the data and conduct database scanning, employ a threat management system, and appoint a third-party assessor to conduct an evaluation of its cybersecurity frameworks annually for 10 years. So essentially, based on what he's asking here, is to live up to EU, UK standards in terms of security, which maybe isn't really a bad thing in terms of protecting the data.
Indeed, and it's getting to the point that, of course, it's coming towards that sort of EU definition of any information that identifies an individual. So in this instance, the sensitive data is social security numbers, full names, home addresses, relatives information that may have been given, so friends and family, and also the fact that this information wasn't being given willingly, in that the individuals in the majority of instances didn't know it was being scraped and collected and used and processed and used for various practices.
Isn't that just fun to think, someone could be scraping data off, the latest thing I posted on my Strava. Isn't that fun?
Well, indeed. Sometimes oversharing stuff on apps like Strava isn't necessarily the best thing because of things like this, and also the safety and security point. But again, story for another day. One thing actually just briefly worth mentioning on this as well is the fact that this feeds into a few other stories coming out of the US, including one regarding Elon Musk and political fundraising, Amelia.
Exactly. So that is my next story. So a pro-Trump political fundraising group backed by Elon Musk is under investigation in Michigan over efforts to collect voter data. This is quite an interesting story in the fact that users who indicate they live in the battleground states such as Michigan, Pennsylvania, Nevada, Wisconsin, Arizona, and Georgia are prompted to enter detailed personal information on a form, including their address, mobile phone number, and age, according to the CNBC News channel. However, voters who live in states that are not expected to be competitive in the presidential election are directed to enter their email address and zip code and then take their state's voter registration sign-up form. So you've got quite a massive difference there in terms of the data that's being collected on these people, and whether they necessarily know the difference is quite interesting.
It is, and what's interesting on this, of course, is that this sort of two-tier collection of data means that for the majority of people who aren't in those very small comparative number of battleground states, your information is being funneled through in that sort of register to vote type way. Whereas then you've got the very heavy information taken from those who are in the battleground states, who then I'm sure will end up being carpet bombed, if you weren't already, with loads of information saying this is who you should vote for and this is why, and that a certain candidate endorses this message, which from a long time since I spent any substantive time in the States now, but it's always an election year in the States. Someone is voting for something, and you always get that wonderful slogan at the end of any piece of political advertising. And I think, for those who aren't in the States, we find it quite difficult to realise that every single advert break, no matter what you're watching, will contain a piece of political advertising. If you're in the States, I don't know how you do. I don't know how you don't end up going slightly insane with it. And it's even the case that it's there on YouTube now and any other streaming services as well. So the point is that you've then got, in this instance, a political action committee, one of these massive organisations that takes donations and then usually funnels it into carpet bombing of advertising, In this instance, is just trying to collect as much personal data as it can, seemingly. In Europe, this wouldn't really hold much water because the whole point is always you only collect the personal data that you need for a specific purpose. So if you were engaged in political advertising and collecting data for the purposes of swaying someone on voting, you'd only do that in relation to the data that you need in order to run that campaign, which arguably will be fairly basic. Yet in this instance, they're taking far more than they need because, of course, they want to do very sophisticated voter segmentation and profiling and data modeling, which isn't really what the point is. But the whole point is that, yeah, they're collecting far more data than strictly you would ordinarily need. And that has potentially put this political action committee at odds. But it'll be interesting to see what, if anything, happens on this one. Will you see any sort of class action? Who knows? But because these things are supposed to be loosely regulated, it remains to be seen what, if any, action is taken. I think the Michigan Secretary of State is looking at this and will be reporting any potential violations to the State Attorney General's office.
Thanks, Peter. Moving on to our next somewhat short story, and this is looking at law firms paying ransomware attackers. If you're a regular listener to this podcast, you will hear us banging this drum fairly recently. And it's quite short, quite simple. Do not pay attackers when you are hacked. There we go. End of story. Should we move on? No, it's more than that. So ransomware hijackers of law firms' computer systems have been paid off on 8 known occasions in the past 6 years, according to a global survey on cyber attacks published. So the report by technology researcher Comparatech identified 138 individual ransomware attacks on the legal sector, with nearly 3 million individual records compromised. So this is significantly less than the previous story, 2.9 billion compared to 3 million.
Yeah.
But nonetheless, we have had from everyone from the Law Society to NCSC to a variety of other organisations all saying the same thing. Do not pay the attackers.
Yeah.
And it comes down to this bottom line, the fact that you can pay them as much money as they ask for. That's all well and good. And maybe if you get a friendly attacker, who knows, you might find one out there that says, oh, thank you very much, here you go, here's your data back. Yeah. That's all well and good. Unless you've got someone that says, oh, great, you've given me this 10 million. Well, I actually now want an extra 10 million. Thank you very much. Then you can have your data back. And then you're stuck in that vicious circle of, okay, well, you're going to pay. He's going to say, no, I want more. And you're not really going to get anything out of it.
No. Exactly. There is no honour amongst thieves. The point here is, and the reason why we put this story in is that even though all those organisations that you've just outlined, Amelia, Law Society, Bar Council, NCSC, ICO, have all said to law firms, do not pay ransomware notices to come in. And furthermore, do not advise your clients to pay ransomware notices to come in. I've been on panels at conferences where I've sometimes said to the panel, what do you think about this? And they'll go, oh, well, there can be issues around liability or reasons around confidentiality and the priorities of the client that can mean that we really should pay them. No, this isn't up for debate, right? And I am angry about this. I'm still angry. This isn't let's have an argument on the head of a pin. This isn't something for hours of beard stroking in a partners meeting or academic, oh, I wonder if we really should. No, don't feed the trolls. Don't encourage criminal behaviour. Don't encourage the ransomware hackers. Because all you are doing is actually damaging the reputation of the legal profession, because then if a client does receive advice from his law firm saying, well, we think you should pay it, get in your lane. Your lawyers, you aren't there to actually talk about the yes or no's of whether ransom should actually be paid. And furthermore, if you were, and from a legal perspective, you'd be saying, don't pay it, which we've just outlined to you, because that's what your professional regulators and the data protection regulators and the government's national security advisors are saying. So, as I say, there is no room for debate or discussion on this. That's the simple position. Don't do it. And just do not advise your clients on this, because if you want to face professional negligence action, when your client ends up being a repeated victim of ransomware attacks based on advice that you gave them to pay a ransom, well, good luck with that. And furthermore, don't presume that your professional indemnity insurer will cough up and cover you if you end up paying a ransom due to a ransomware attack on your firm and then presuming that the insurer will cover it all. Read the small print. Guess what? Like all insurers, if they can find a way of not being able to pay you, they will. And if they've construed the cover in a certain way to give you a smaller insurance premium at the outset, that's what's probably going to happen. So just for the avoidance of doubt, as I say, I hope that's perfectly clear. If not, do contact us.
Thanks, Peter. Moving on to our next story, we are looking at Google's illegal monopoly. So a US judge has ruled Google acted illegally to crush its competition and maintain a monopoly on online search and related advertising. The landmark decision earlier this week is a major blow to Alphabet, Google's parent company, and could reshape how technology giants do business. So Google was sued by the US Department of Justice in 2020 over its control of about 90% of the online search market. And it's one of the many lawsuits that have been filed against a big tech company in the US on antitrust grounds. So Peter, I'll pass over to you to talk about this in more detail. And it's quite interesting because, I mean, even in casual conversation, if you're saying to someone, oh, I don't know about this, and says, well, I'll Google it. It's a household name, isn't it? So, right, go away, Google it. And that's actually just a search engine.
Yeah, but it shows how embedded it is now in its dominance of the market, not just in the US, but globally. And this is a persistent issue that's come up. They've been fined in the past in Europe and in the US with regards to deals that were signed up, meaning that Google search was embedded in certain products and services. So it used to be the case that when you got the Android phone, actually on the Android background desktop, you'd have like a window on it where it just took you straight into Google's search, and it was pretty difficult, if not impossible, to uninstall that on certain Android models. Now, the point is that they've carried on with this sort of behavior. Okay, you might have hegemonic domination of a market, but having fought to get that, they've then fought very hard to maintain it. And that has meant signing various deals with different other organizations to try and make sure that you still get promotion of Google search engine through Apple, through Mozilla's products. And they say, oh, well, we're facing strict competition here from Bing. So you're like, really? Bing is your threat, is it?
The last time I heard Bing in conversation outside of when we were discussing this earlier.
Yeah, exactly. So what's interesting with this is that there is a 277-page judgment that the judge has produced. Interestingly, the US Attorney General, who, for those who are outside of the US, the Attorney General is basically the country's top prosecutor, Merrick Garland, he has turned around and said that he called this a historic win for the American people. So he's got off the fence there. No company, no matter how large or influential, is above the law. The Justice Department will continue to vigorously enforce our antitrust laws. Apparently, there are other similar actions pending against Meta, against Amazon and Apple, all accusing them of operating unlawful monopolies. But this is the first one that we've got a judgment on the back of a 10-week trial that took place in the US. So we don't know at the moment what the potential penalty or enforcement that Google's going to face in the US is.
And whether it can be appealed as well, you know.
Yeah.
When it has been levied, it could drag on for a lot longer than it already has.
Sometimes you've got to have a very good reason why you can then drag something up to the Supreme Court, which is what you'd be needing to do in this instance. And Google got to think, do we want to fight that? Would we want to do it? And can we find a reason? It's not automatically the case that you get leave to then take it to the Supreme Court. And furthermore, given the Supreme Court's current makeup, would it necessarily disagree with that view? It will be difficult to see. Who knows? You never know what you're going to get out of the US Supreme Court. Let's leave that there. But the point is, as well, is that on the back of this, you made the point, Amelia, that I wonder if Europe might be tempted to look at that 277-page judgment when it's thinking about how to apply its Digital Media Act, the EU's Digital Media and Digital Services Act, because that's seen as having swinging powers that allow regulators to turn around and take quite a strict line with tech firms, the majority of which, of course, are based in the US and California. And it will be interesting to see if, I've heard a lot of tech leaders have turned around and basically see the DMA as just a reason for Europe to hit tech firms quite heavily. Will Europe decide to take this US judgment and see which bits can then apply to European law as well.
I think it's very possible. I mean, if the US sets quite a damning precedent here, that it could be carried over. I mean, the US in the past has almost accused the EU of kind of coming after these big tech companies. And if they themselves have then ruled it a monopoly, then what's stopping the EU from doing the same? Probably not a lot, I would think.
Yeah, exactly.
Moving on to our next story, we are looking at the Essex School reprimand for using facial recognition technology. This is quite an interesting one. I actually got this story delivered to my inbox from the ICO, and I was pretty shocked to read it because essentially they have issued a reprimand to a school that broke the law when it introduced facial recognition technology. And this is to make cashless canteen payments from students. So of all things, it's cashless canteen payments.
Yeah.
So essentially, the facial recognition technology processes biometric data to uniquely identify people and is likely to result in high data protection risk. To use it legally and responsibly, organisations must have a data protection impact assessment, DPIA, in place. This is to identify and manage the higher risks that may arise from processing sensitive data. And, we are talking about a school here, so naturally, this is going to be sensitive data, wherein you've got the school pupils aged from 11 to 18, so you've got those under 13 involved, which, there we go. And if you've then got those in the canteen that have registered health issues such as diabetes or serious food allergies and intolerances, then you've got quite a trove of data that could be being stored under this. So essentially this school, Chelmer Valley High School, with around 1,200 pupils aged 11 to 18, failed to carry out a DPIA before starting to use the facial recognition technology. This meant that no prior assessment was made for the risks for the children's information, and the school had not properly obtained clear permission to process the students' biometric information, and the students were not given the opportunity to decide whether they did or did not want it to be used in this way. So essentially, they failed every single hurdle when implementing facial recognition technology, and to be honest, I still can't see the benefit of using it in the first place.
Well, just for the benefit of a certain group, and I class myself as being in this group, the group of people who went to school more than, say, 20 years ago. Let's call them the old people. Because I find myself just looking at this thing, just for the love of God, what's wrong with cash? Because I used to be given dinner money, and then the dinner money was what you used to buy the food in the canteen, which wasn't very nice, but that's what you did. And apparently that's not what happens now. Amelia, why is this? Why are we just not using money? Why do we have to involve electronics and facial recognition technology in my
old school? So I think, how long ago was I in school? Probably let's call it between 8 to 10 years ago when I was at school.
Yeah.
And I think it was in my last year we implemented this, and it wasn't facial recognition, it was still biometric data. They used to use your fingerprints. I was one of the lucky ones that did not have to go into the canteen, and you know what, I never stepped foot in there. But essentially your parents could go and upload money into your digital account, and then you have to scan it with your fingerprint. I think part of the reason that this was implemented was to look at managing obesity, was one of the reasons. Because in doing so, your child could not save up loads and loads of money and put it onto the system themselves and then buy whatever they wanted, because a parent could log on and see what their child was eating for lunch. Therefore, in my school, it was pretty much pizza or pasta. Therefore, if you saw your child eating 15 pizzas in one day, you knew that there were a few red flags to be had there. And I think that's where this has come from. But is it necessary and proportionate? Definitely not.
Yeah, I mean, thinking about it, I've heard about, where, for example, you might be given a card that then is loaded with money and you use the card in the canteen. So I suppose this is just an extension of that, as you say, from the card to then biometric data where you use your fingerprint, but then full-on facial recognition technology. It's always the thing with facial recognition technology. Even when you can use it, scan your face to unlock your laptop or your phone, it just strikes me as just that little bit Orwellian and sinister.
It's a bit creepy, and I will never forget when my brother managed to open my phone using facial recognition technology. And my brother does not.
Shows the limits of the technology there.
Well, yes.
Yeah.
And my brother does not, quite frankly, look like me. And this is where, again, I think in the last couple of podcasts, we've discussed the issues with facial recognition technology and the fact that some people, you get mistaken identity. And what's that going to happen in schools when, kids are changing regularly? 11 to 18, that's the period where you suddenly go from looking like a child to looking like an adult. And is the facial recognition really going to process the information correctly? Who knows?
Indeed, because you can imagine then that a facial recognition technology scan will probably only be good for the year, and then you've got to go through the whole thing all over again.
Yeah, because if you think about that 6-week holiday that we are currently recording this podcast in, kid could go from being a baby face and having a full beard by the end of the summer, such as puberty, and therefore then what's facial recognition going to think?
Indeed. But the thing here as well is that the school would have avoided the reprimand if they had carried out a data privacy impact assessment. Blatant plug here, Amelia. How do you get a data privacy impact assessment?
Well, we can help you do one.
Yes.
And there we go, blatant plug.
Yeah, that's one of the things we do, is we do data privacy impact assessments for clients. And we work with them, and we do it in a straightforward, easily understandable, relatable, plain English way, and we don't think we're too expensive. There you go.
And hey,
end of plug.
And no, I'm not finished yet. We can also give you a template. So once you've done this big old job, we can also guide you through the process so that when you have new projects, such as implementing facial recognition technology, which we are no way plugging at all, but you could then use it to carry it out yourself as a tool.
Yes.
And there we go. That is. Oh no, you can.
I was just going to say, actually, our approach actually is always that we try and train people within our client organisations so they can do all of this stuff themselves. Really. Exactly. It's more sort of support, so that if you have a designated person, we'll gradually give them the tools so that they're able to stand on their own 2 feet and do this stuff. So it's not like, oh, we're forking out for a regular expenditure on this. It's like, well, no, develop the skills within your own organisation is what we prefer to do, really. Exactly. And schools are a place where you should be getting these things right. You have got a lot of data naturally as you're a school, and you need to know about the people that you are teaching, educating, etc. Therefore, it shouldn't be too hard to think that you need to have the right processes in place to get these things right. So there you go. Clang, promotion over. Moving on. Moving on to our next story, which is ironically about promotion. There we go. We are looking at Huel and Zoe advertisement ban. So misleading advertisements for Zoe and Huel featuring Stephen Bartlett have been banned by the advertising regulator because the companies failed to disclose their commercial relationship with a celebrity entrepreneur. So essentially, both companies linked to the 31-year-old who was an investor in Zoe and a director at Huel, neither of which was very clear from the adverts. And 2 adverts for Huel were likely to mislead, the regulator found, while Zoe advert was misleading according to the ruling seen by the time. So essentially, there's just a lot of misinformation there. Yeah, and I think the reason why I wanted to just briefly look at this is that this is an interesting development in the field of online advertising. An awful lot of advertising now is through celebrities, influencers saying, oh, I use this product, or isn't this great? Ad. And exactly, you have to include hashtag ad or hashtag gifted or some level of or a dollar symbol or just something to show that something may have changed hands, even if it isn't a financial amount. Sometimes it's like if a celebrity's saying, oh, this pair of trainers is jolly good, they've probably been given that pair of trainers to say this is a nice product. Or even, those celebrities, like in this case, where they are flogging their own products. You've got many celebrities now that have gone from, for example, acting or singing to then having their own brands. You've got Rihanna that's now got Fenty Beauty. You've got Selena Gomez, who is now Rare Beauty. You've got all these products that, well, if you're a regular social media user, you might assume that it's common sense to think, oh, yeah, that's their brand. They're flogging their own brand. Cool. Yeah. But no, you still need to have that hashtag ad or hashtag gifted or hashtag paid promotion, some level of knowledge that is being flogged by the celebrity for that reason. Indeed, in this instance, the ubiquitous Stephen Bartlett, who is the first person who appeared with a business on Dragon's Den, he's the first person to then become a dragon. And he's all over social media, very personable. I've seen him speaking at conferences and events. And he appeared in a number of adverts earlier this year for the Zoe tracking app. This is an app that basically You pay a subscription, they give you a glucose monitor to look at your blood sugar levels, and then you can subscribe to various services. The idea is it helps you work out which foods you should or shouldn't eat. And he did a series of adverts that appeared on Facebook saying, this is a really good thing, this will change your life, really, really good product. But it wasn't clear that he's also an investor in Zoe. And I must admit, I remember seeing those ads at the time, and I thought, Stephen Bartlett uses that. Oh, look at that. I did not stop and think, well, obviously he was an investor or had some other link with the business. Similar thing with Huel. This is one of those things where you can...
I think it's like a meal replacement sort of thing, isn't it?
Yeah. So he ended up doing a similar thing on that. Oh, drink Huel. It's jolly good. But never actually said that he was a director in the business. There's nothing wrong with him doing that. There's nothing wrong. He could have run these ads. It was just be a matter of making it clear that using those sort of hashtags or acronyms, whatever that we talked about
or
earlier.
even just outwardly saying, here's an ad, here's a plug, as we did.
Yeah.
Here's the plug.
Yeah.
There we
Exactly.
go.
I mean, it's funny, the rules are different if you're advertising on TV. But I always think that there's, I'm going back probably to a good 10 or 20 years before you were born. But there used to be, when they used to advertise Remington shavers, there was advertised by a guy called Victor Kayan. And the tagline was always, he loved the product so much, he brought the company. And then he was the guy in the advert saying, I use Remington shavers, and they're great, I own the company. Like, oh, that's nice.
There we go.
Because obviously anyone can just turn around and buy a company, but it's
But there we go, it's to the point, and you know what's going on there.
It's fully disclosing the nature of your relationship. That's the thing. And in this instance, that's not what happened, and that's where the Advertising Standards Agency tends to get a bit of a sense of humour failure. So in this instance, that's where they felt that viewers would feel they were being misled.
I'm conscious that we are giving Stephen Bartlett a bit of a kicking here, but other celebrities have also found themselves in a spot of bother doing this. I know that Grace Beverley, she found herself in a spot of bother by doing the same thing, as have a few other celebrities as well, where they've just not included that hashtag ad or, plug or whatever you want to use to indicate that there is a level of partnership there. And that's the bottom line.
About 10 years ago, similar thing happened with Wayne Rooney. So when he was in his pomp, still playing, he'd sent out a couple of tweets, or I should say his advertising team sent out a couple of tweets, but they didn't contain that sort of hashtag ad or a pound symbol. So therefore, it wasn't clear that what he was talking about was actually part of a commercial relationship with, I think, someone who was supplying him with kit at the time. But it just sort of illustrates the point. You have to be open and transparent about these things.
Thanks, Peter. And if you're still with us after all of those stories, we are now on our final story of the episode. And it's probably one of the most interesting stories that I think we're going to be covering today. And this is the Digital Will Service. So obviously, you know, most people listening will understand what a traditional will is. It's this piece of paper, you have executors and all this, that and the other. It's very proper. However, we are now in a time where most of our lives are being lived online. You've got a variety of social media services. At this point, you can create digital avatars, profiles, dating apps. All of this is online. But there is quite a big problem that if someone dies, what happens with their social media accounts? Because that's quite a big sticking point for some people. And you can understand why, because if, you're still getting someone's annual birthday coming around every year, flagging happy birthday, and they've been dead and gone a couple of years, then it's not really appropriate. So this story is looking at how a website called My Wish enables the easy creation of a digital or social media will. And experts are also recommending appointing a tech-savvy digital executor who can take charge of closing, accessing, or memorializing accounts so that they are preserved online. So quite an interesting story, this.
It is, and I think it becomes more and more relevant with every passing year, where people live more and more of their lives online. You've already talked about your Strava account. Very often people have got accounts on Facebook, LinkedIn, X, Instagram, whatever. And sometimes there can be a lot of content up there. Sometimes it can be actually the way of then being able to access that content about someone, if it's photographs, videos, etc. Friends and family after someone's gone might want to say, well, actually, we'd like to be able to get hold of those posts and be able to remember that person in the way that 30, 40 years ago, you put pictures in a photograph album. Now it would be drawing together some of those digital assets and material. But as anyone who has had a family member who has passed and then tried to either get a social media profile taken down or to access the information on there, you'll know that there are very often very tight rules imposed by the social media platform in terms of who is then able to access that profile. And if you do not meet that, you could be, what you think is a close family member or a close friend. Very often it's only immediate family, i.e. Parent or direct child, is the only way you'll be able to potentially get that access. So if you're, aunt, uncle, grandparent, grandchild, they'll go, tough, no, we're not speaking to you. We only want to speak to those close people. And for those close people, they might not really want to, particularly if they're still upset about the fact they are bereaved, etc. So it can be a difficult thing to deal with. And having all of this taken care of through something like My Wishes is, I think, the next logical step. If you are preparing a will, and let's face it, everyone should, the idea of having some arrangements in place with regards to how you want those digital assets to be treated in the event that you're no longer around just kind of makes it all easier for those who are left afterwards, who might be dealing with an estate, dealing with trying to put together a funeral or a memorial and thinking, we'd really like to have that video, we'd really like to have that picture of someone, but otherwise we might not be able to get hold of it.
I also think it's just forward planning in an age where, wills have been around for such a long period of time, and that they have changed. It used to be, you used to tell your next door neighbour, here you are, you can have my field if you die, and that was signed and sealed. Great, jobs are good. But now, obviously, we have
that
the
wasn't
whole
legal advice, everyone. Just for the avoidance of
doubt. Then now you've obviously got the whole, you have to write it down, you have to have it notified, all of that. But thinking, forward planning, if you've got assets that are not necessarily physical assets, we are in an age where you've got cryptocurrency, you've got NFTs, other things that you can't, that maybe are not covered in a will, or maybe are not necessarily thought about, that should be covered in more of a digital aspect. And I think it'll be interesting to see how many of these actually then come about.
Yes.
Where you've got the level of, okay, especially if you think of someone that I know more recently, people have documented their cancer journey, for example, and that's quite a thing on social media, and where you've got, for example, Balbabe. She was very active on social media.
Yeah.
And I imagine she then took legal advice in terms of what was going to happen with that account, and she sadly passed away. And that's the sort of thing that you want to and need to think about when we do live online.
And I mean, the thing is as well, because of the way that a lot of these social media platforms take a very black and white view on how they apply the rules when it comes to privacy. If you are then trying to get hold of, like you say, a social media profile like that, it's actually, as a relative, even if you are a close enough relative, it's still a little bit like passing through the eye of a needle. Please prove this, please prove that, please provide blah, blah, blah. And if you are somewhat vulnerable or fragile following a bereavement, anything you can really do to reduce that burden is worth doing. And in this instance, I think being able to have that digital footprint effortlessly passed to the person that you want to then have that control of seems eminently reasonable to me.
Absolutely. So that was our last discussion of the episode. And if you have any questions about anything that we've talked about today, please feel free to email us at admin@digitallawuk.com. And a summary of today's stories are available on our website, as well as the links to the original stories containing more information. And if you'd like to hear more from us, including information about subscriber-only podcasts, webinars, events, then please subscribe to Premium via our Patreon channel using the link in the show notes. A big thank you to Ansell Evaluate for helping to produce this webinar. And if you'd be interested to hear more about Ansell Evaluate services, please take a look at their website. You can find it at www.ansellevaluate.com. And just a reminder, these episodes are available on our website, YouTube channel, podcast channels such as Spotify, Apple Music, Amazon, and please feel free to leave us a review. Thank you for listening, and we hope to see you again next week.